what to look for heading into the NRA Annual Meeting, plus the latest on a New York engineer sentenced to 10 years in prison for making his own guns. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski, founder of thereload.com, where you can head over right now and sign up for a free newsletter to stay up to date on all things going on in guns in America. And speaking of gun news, Stephen, you're actually going just actually shortly after we finish recording here down to Dallas, Texas to report on the NRA Annual Meeting at a very pivotal time for the organization, as we're sort of still waiting to see what's going to happen to it, where it's going to go in the future. And you wrote a couple pieces for us this week in the newsletter, just kind of breaking down, what's up in the air right now and where things have been and where things might head.
Yeah, absolutely. I will be there. I'll get in pretty late tonight, but I'll be there tomorrow when you've got the members meeting and the leadership forum where Trump is going to be speaking, as well as a handful of other Republican elected officials. And then also the board meeting on Monday. I'll be there to cover that too. That's where you would expect to see those three events really are where you might expect to see, signs of what's coming for the NRA or what direction they're going to head in. And, things are pretty urgent at this point. This is probably the last time that they're going to have an opportunity to change course, if they're going to change course before this second phase of the New York trial, the part where the judge is going to determine what to do after the jury found that the NRA failed to safeguard its charitable assets, that it retaliated against whistleblowers, including a number of reformers who were just elected to the board recently, and that its former leadership, including Wayne LaPierre, had, essentially taken NRA money and spent it on their own personal expenses to the tune of millions of dollars. So the judge will decide after the second phase what the appropriate remedies are for that. So, if they're going to try and change course at all before that happens, this is probably the last time they'll be able to do it, I think. And, of course, that's goes to the question of whether they should change course, because there's going to be two very different views on that. One from the current leadership, people like the President Charles Cotton, or interim CEO Andrew Willanundum, or Bill Brewer, the outside counsel for the NRA, who's directed most of their legal strategy the last half decade or so, since this corruption scandal began. They really want to stay the course. This has been their argument all along, that, there had been some mistakes made. Generally, they blame people who are no longer with the organization, like Josh Powell or Chris Cox, or they even to a small degree Wayne LaPierre, or Woody Phillips, the former treasurer, who was also found liable in the case. But their argument is that they've already made the internal reforms to fix those issues and no further action is required. The jury seemed to disagree with this, at least to some degree, especially with the whistleblower part of the trial, part of the findings. But that's their argument. That's what they want to stick through the end of the trial with that. And so, one of my stories that I wrote that was published today just basically pointed out the fact that they haven't made really any changes at all since that jury handed down its verdict in the case. And pretty much business as usual. Wayne LaPierre is actually still showing up in their promotional marketing for the annual meeting. He was the kind of the star of the video that they put out when they announced this meeting. So they haven't even really distanced themselves much from him, even though the jury said that he basically stole $5.5 million, diverted however you want to say it. And I believe in court they're trying to. Wayne's lawyer is trying to get that reduced or thrown out, but so is the NRA, somewhat ironically. But and obviously his allies are still in control of the organization. Cotton, Arulnundum, Brewer, these are all people who were very close with Wayne and part of the leadership team before Wayne resigned. So hasn't been any difference there. They haven't changed, the lawyer, John Frazier, who was found to have been responsible for lies on the NRA's legal filings. He's still there. There's no change there, no punishment as far as we can tell. Almost nothing has changed at the organization. And so that's the course that the current leadership wants. And that's what they argue is going to be best for the organization. They think they'll win eventually in the end. And that changing course would be worse decision. Obviously, on the other side, you have the reformers, right? We have written about them at length. We've had them on the show. Love to have current leadership on the show, but they have declined to come on and face any of these questions, maybe for fairly obvious reasons. They don't want to do that. But regardless, the reformers want the exact opposite. I mean, it's pretty simple. They want a clean sweep of leadership. They want reforms to how the NRA operates, including its bylaws, its board, all of that. And they've been going that way since the beginning of the corruption scandal, right? Since the bankruptcy filing, which didn't work, since the allegations against Wayne first surfaced. That's what these guys have wanted. And, they haven't honestly had a ton of success inside of the NRA to this point, or even there haven't been a lot of signs that NRA membership are hearing and agreeing with them until just recently. This election where they ran as a slate on this platform to reform the group, and they were among the highest vote getters in that election. They all got elected. That sends some signal. I think the verdict perhaps helps these reformers as well, changes the dynamics a bit. So does Wayne's resignation. I think a lot of the reason that you didn't see most board members trying to change course the last 5 years is due to not just some of the tactics that leadership had used to kind of silence some of these dissident board members, like removing them from all their committees or really just shaming them and yelling at them during board meetings, things like that, which did cause a lot of people to resign. But there's also just been a lot of pent up loyalty to Wayne because for fairly reasonable reasons. Fairly reasonable reasons. He obviously was the leader of the NRA for a long time and led it through the period of growth that it saw to where it became one of the leading, not just gun rights organizations in the country, but political organizations in the country. And so there was a lot of reason for people to have a great deal of respect for him inside the organization. Now, obviously, he was doing this while simultaneously, according to the jury, diverting money to himself from the NRA's charitable assets. So, but that pent up loyalty has served a big part, and it's gone. He's not there anymore, at least not publicly working for the NRA anymore. So there are things that have changed. There's some reason to think these reformers could have more success now this weekend than they've had in previous years in trying to force substantial change from within. Now, again, there's only 5 people on that slate of reformers, and it's a 76-person board. So we don't know what the rest of the board is going to do, how they're going to react. But we will see. And that's, I think that's the big thing, the big fight that's going down. And so a couple signs we can look for while we're there. And I'll be reporting, obviously, live from Dallas. How the members meeting goes, that's on Saturday. The board meeting's on Monday. A lot of the decisions are going to be made on Monday, but Saturday could tell you something depending on how many people are showing up to this members meeting, what the atmosphere inside of it is, if there's a lot of passionate opposition shown to current leadership during that meeting. That could give you some sense of where the membership is at, how many people still care about this after 5 years. And then also how current leadership handles that opposition in the members meeting. If it materializes, might tell us something too, might tip the hand at their position on all this. Cause the last couple of times that you've seen outbursts during the members meeting, that you had a lot of board members go up and defend Wayne and other members of current leadership in really stark terms. Like they go up there and they hash out, they yell at these dissidents, the people who've been, Jeff Knox and Phil Journey and Rocky Marshall. You'd get a lot of folks going up to yell at them, really. Prince and Tom King and a number of current board members have done that historically. And so we'll see how that shakes out during the members meeting. It could give you some indication for maybe the internal politics of the NRA at the moment.
Yeah.
But yeah.
Sorry, I was gonna say that to me is fascinating because I've been curious throughout this fight is how much of this has trickled down to the remaining members that are there. Obviously, we've seen at least some evidence of a defection of membership. We've reported several times now loss of more than 1 million members, possibly more than that, even depending on who you ask. And do the remaining board members, have an appetite for this change, pushing it from within like that? Obviously, there's some evidence, right? This slate of reform candidates got elected, and that takes elections from NRA members.
I think that's the first real evidence too.
Yeah.
There's lots of stuff where you've seen the reformers go out and want to raise money or try to gin up opposition internally and not have much success with it, frankly, over the last 5 years. You're not getting some clear sign that they're getting through to the membership and that the membership in large part is on their side, other than the defections, right? We've had a lot of people just kind of leave, but you've seen that with board members too, right? At a certain point, the board members who had expressed, there's probably if all of them had stayed on board, you'd probably have closer to a dozen people on the NRA board right now who have, there've been more than a dozen, I think, NRA board members who have spoken up about their unhappiness with how the group has been run and these allegations of corruption, but a lot of them have resigned. And you could take that same tack for the members who have left the NRA. That part, maybe some of that is because they're upset with how the corruption side of things. There could be other reasons too, right? They lost a lot of people during the pandemic when people were, generally cutting back on things like charity expenses as they tried to just get through the pandemic. But yeah, I think the board elections are the first real clear signal that a significant number of the members who are most engaged, the people who vote in the elections, seem to agree with the reformers. But
yeah. And I think, you mentioned this already, but I think it's worth repeating the fact that at least where the current remaining leadership is at, the fact that Wayne LaPierre is still on the promotional materials for this annual meeting, despite the fact that, this was major news that he stole money from the NRA members, essentially. And so the fact that they still have no problem using him in promotional materials, at least I think is revealing where current leadership is at, where they don't think it's maybe as big of a deal to the members. And we'll have to see if members feel the same way, because I think that's pretty remarkable.
Yeah, I mean, it really is. The jury found that he that he was liable to repay the NRA $5.5 million for these personal expenses that he made with NRA money over the years. And that's really only over a few years, because it doesn't go back for the whole, 30 plus year history of Wayne at the NRA. It was only this, period of time that they could capture in the statute of limitations. But yeah, it is pretty remarkable to see them. And his resignation even it wasn't like they forced him out, or at least the way they talked about it. They said that it was for medical reasons, which he has had medical struggles in recent years, from everything my sources inside the NRA have told me. It's not made up. But, so from the NRA's point of view, from what they've said, Wayne didn't leave because of any of this. And Wayne He repaid some of this money, about somewhere around $1 million is what he claimed to do. And, the NRA has not been seeking further damages from him. And so, because current leadership, that's been their approach. They don't want to go after Wayne. A lot of them, again, are his longtime allies at the organization. So there hasn't been any real change in how the NRA runs, even though Wayne has technically resigned, because the people who run it now are all the people who were his longtime allies in the organizations. They're running it the same way he did. And you're still seeing things like the private jet travel. There's a difference, right? We've talked about this before, that Wayne's private jet travel was determined to be in large part not for NRA business. He was flying around his relatives, things like that. And he was adding trips and trying to hide them from the NRA's books. He did a lot of that kind of, this is what the story we broke recently is not identical, right? This was NRA President Charles Cotton has traveled on Bill Brewer, the NRA outside counsel's private plane. Now they say that's for NRA business. And they also claim it saved the NRA money. Paradoxically, that's the claim, but so it's a little different. He's not accused of spending NRA money on personal flights, here or there, but it's in the same realm, obviously, of things that got the NRA a bad reputation for wasting their donors' money. And so you still have a lot of the same even issues going on at the NRA, despite Wayne leaving. So, I think that's really the clash you're going to see, is like these reformers newly emboldened with the verdict, with Wayne being technically not in a leadership position anymore. Who knows what he's doing behind the scenes. I would be very surprised if he is not involved in some way behind the scenes, but I don't have any reporting on that. So just speculation on that point. And, also the election. I think that those are all things that go in their favor, but they still are a small group, as we mentioned, at least publicly. We don't, the rest of the board has not come out and publicly made noise about backing these reformers. They might be doing that privately. I don't know. But we certainly we've reported on some letters that have gone around, board members complaining or offering up new leadership suggestions, or complaining about getting cut off and from the NRA's contracts. There's stuff that's flying around. There's a lot of it, but we don't have like a public declaration like we have from these reformers. They all ran on a public platform that they wanted to bring internal reform, and we'll just have to see how many people are going to actually go along with that when the board meeting rolls around.
Yeah, no, we look forward to your updates, and hopefully we can see what happens. Because like you said, this is probably the last time anything can happen before the actual sentencing part of that trial or the punishment part of the trial takes place this summer. So we look forward to it. One of the other big stories we wanted to hit this week is about the ongoing saga around the case of Dexter Taylor. So for folks that don't know, this is a man in New York who was charged and actually just recently sentenced to 10 years in prison for making homemade firearms, including AR-15s, 3D printing some firearms. And it's sort of, it hasn't caught a ton of major media attention, but it's certainly caught the gun world by storm, just because, 10 years for, self-manufacturing firearms. He didn't have a criminal record. He wasn't selling these firearms. There's no evidence to suggest that he was selling them. He never, used them to commit a violent act, but was still charged with violent felonies and given a 10-year sentence.
Yes, this is a case that has been undercovered, I think, so far. You'd had Jeff Charles at Red State has been one of the only people who's done reporting on this. So he's really been bringing it to light. But Reason had a piece on it that we linked to as well, just on some of the statements made by the district attorney there, trying to justify why they've gone this route of like throwing the book at this man, who again is not charged with. He's basically charged with possession and paperwork crimes. He built his own firearms. There's no evidence he used them to harm anyone, or did he no evidence he tried to sell them to anybody, anything like that. He's from all accounts, he's a hobbyist who likes, he's an engineer. He likes and a political activist who likes the idea of building his own guns and agrees with the political philosophy behind that, which again, building your own firearms is legal almost everywhere in the United States and has been since the founding era. It's only in much more recent times where you've seen laws start to pop up in places like New York, as some of the first in the country where they're banning self-manufacture of firearms, or and obviously he also ran afoul of their assault weapons ban by building ARs. So there's another aspect to it. But the DA there is, as Reason pointed out, basically said he wanted to make an example of him. And that's why this was such a harsh sentence. I mean, harsher than you're going to see actual violent criminals get in a lot of cases in a place in New York, right, especially for somebody who has no criminal record. It's pretty wild that they've gone this route. And he, it's very interesting. I spoke to his lawyer yesterday, and we may have him on the podcast at some point. His name's Vino Bagisi, I believe. Apologize if I pronounced that wrong, but his lawyer might have him on the podcast, or I'm hoping to interview Dexter directly himself from prison. Unfortunately, he's going to be in prison during any appeal attempts, and his lawyer did not have a bright outlook on what's going to happen with this case. Dexter is, from all accounts, he seems to be committed to fighting this from a principled standpoint. Like he's not willing to take plea deals, I guess, is what it sounded like. And he wants to try and get this law thrown out, which is probably not going to happen in state court. I mean, there was a whole story about the judge, not allowing Second Amendment defense as part of the state court proceedings, and even saying some fairly inflammatory stuff to that end. Like, this is New York, Second Amendment does apply here. I think she's trying to say that you can't use the Second Amendment defense in this particular proceeding, but it came across as much more aggressive than that, obviously. Absolutely. And the big problem is his lawyer thinks that he has a better shot in federal court, and they want to get to that, but it's probably going to take years, is the reality, because he has to go through the state appeal system first, where he has much less of a chance of really succeeding at all, because the facts I don't think are under dispute. He doesn't try to say he didn't violate these laws. He just thinks that they're unconstitutional, and he wants to challenge them in that regard. And that is a very hard thing to win at the trial level. In these cases, you have to bring, a constitutional suit after that, which, I know we cover those a lot, obviously, right, but they're hard to win. They are, in reality. Like, they're not an easy thing to do, and it's going to be a long slog. And it probably means he's going to be in prison for years. It seems like at this point, which is fairly outrageous situation, honestly, given the charges. But I want to look more into it, and obviously, hopefully, hear from Dexter himself in the future. But right now, he's sentenced to 10 years. He's in prison as we speak. It seems unlikely that he's going to get out anytime soon. Although I will say there's some hope, I think, for a shorter term victory that won't come directly from his case. But on Thursday, the Supreme Court issued opinions. Again, it didn't issue any gun-related opinions, although it did issue a fairly interesting text history tradition ruling that dealt with the consumer protection. Was it Consumer Financial Protection
Consumer
Board?
Financial. Yeah.
Which where Thomas wrote the opinion and used the text history tradition standard to uphold the creation of that board, even though it was created by Elizabeth Warren and Barack Obama. It's not something that conservatives politically like, but So that was kind of an interesting thing, but no gun related cases. They did have their conference where they're considering new cases, and they have a slate of AR-15 ban challenges, so-called assault weapon ban challenges that they're considering. Now, we don't have any news on that. We might get some on Monday. It's not clear that they're going to take these up, and oftentimes the court will relist cases a bunch of times for consideration before they actually decide whether to take it or reject it. That's super common. So we might not know on Monday, but regardless, if the court takes an assault weapons ban case, one of them, there's a bunch, Illinois, Maryland, California, then if they find that bans on AR-15s are unconstitutional, that could have an effect on Dexter Taylor's case, because that's part of what he's charged with. Not everything, but it's certainly part of it. And so there may be other cases that are kind of further along, more developed, that could impact his particular case. But for him to get all the way to his constitutional challenge in federal court will probably take years.
I was going to say, that alone just speaks to how long that process is going to take, right? Because even assuming the Supreme Court agrees to take one right away, you have to wait another year for them to even hear the case,
right?
And possibly another year to issue an opinion. Then the opinion has to go get applied to other courts, and there's litigation to get those decisions applied to, existing cases. And all of this just speaks to, gun rights advocates think, this is clearly unconstitutional. This can just be a quick challenge and we'll get the charge overturned. And no, this to what the lawyer said, and to your point, this is a several year process. And in the meantime, he's going to be in prison while this all plays out. That's
the reality of these sorts of cases. Unfortunately now. Now I want to hear more from Dexter and from his lawyer and get some more detail here. So I think we'll have some more reporting on this in the coming weeks, and we'll have more for you guys on this particular case. But it's a pretty remarkable one. It's not a kind of case you see every day where somebody's getting 10 years for possession where there's no indication that he had criminal intent beyond just building the guns himself. Like there's no indication that he ever was going to try to use them in any criminal acts beyond just owning them. And that's a really harsh sentence, obviously, especially in a place like New York, where they've more traditionally tried to be more lenient on even actually violent criminals. So it's wild. And I think it's going to be something that continues to get a lot of attention in the gun rights space moving forward.
Absolutely. And listeners can stay tuned for when we have future updates in the case, hopefully. One of the last stories we want to hit today comes to us from the Courthouse News Service. It's about a recent Ninth Circuit ruling surrounding an interesting California law that we covered a couple of years back when it passed, because it's the first law in the nation that we were aware of. And I think it still is the only law that does this, where California essentially directed the Attorney General to share gun owners' personal information when they purchase, firearms and ammunition, because there's a registry in California. The Attorney General is supposed to share that information with UC Davis, researchers at UC Davis, and then he has discretion to share it with other research institutions.
Anyone.
Yeah, that's literally the language, is other research institutions. So gun owners obviously were very concerned about the privacy implications of that. We've seen countless times where gun owners' information has either been linked inadvertently or some claim, intentionally.
Yeah, especially in California, right?
In California,
they leaked the
specifically.
entire concealed carry database at one point.
That's right. And so there were several lawsuits challenging this. It got dismissed at the district court level, and then there was an appeal. And just recently, a 3-judge panel on the Ninth Circuit Court of Appeals said that gun owners, it's not a violation of their privacy rights, because I guess it's not sufficiently a privacy violation that it implicates the Second Amendment, was essentially their core holding. But so gun owners or gun rights advocates rather, were dealt a blow with that ruling.
Yeah, absolutely. And I wouldn't be surprised if you get more of these leaks that come out of this sharing system. I mean, it sounds like they have a pretty permissive view of who's going to be able to have access to this data, which does include a lot of personal information. So I think their goal is to share it in a sort of anonymized way, but there's obvious problems with that,
especially in this day and age, right?
Given the level of detail of some of this data, it's, I don't know. It doesn't sound Yeah, certainly not a win for the gun owners in California.
Right. And there's already evidence that that research or the information is being shared beyond just UC Davis. I guess in the lawsuit, they mentioned that Stanford researchers at least also have access to this information. So I wouldn't be surprised if, emboldened by this win, that information gets shared more widely.
Yeah.
So
I would expect it to. And I do wonder where they're going to draw the line on what counts as a research institution. Like, are the gun control groups going to be able to get access to this information for, whatever research projects they put together? Because, every town releases research of their own. Giffords does, these groups do that stuff too. And I don't think a lot of gun owners would be comfortable with their personal information being given to them. I mean, I don't think they're probably not comfortable with being given to universities either, but yeah, it's an interesting way they've come down on that one. Perhaps we'll see further challenges of it as well, but that's what we've got for now on our news update side of things. But this week we actually have a member segment, one of my favorite segments. I think you're probably going to hear me say that again right now as we go into this, because I always start the member segments that way. But yeah, let's head over to that. All right, it's time for one of my favorite segments, the member segment, where we get to know a little bit more about the community here at the Reload that supports our reporting, that makes all this possible with their membership dues. And this week we have someone from actually way up in Alaska. Steve Wells is joining us. He's a Reload member. Welcome to the show, Steve. Thanks for coming on.
Thank you. I really enjoy it.
Yeah. Can you tell people just a little bit about your background? Because actually, I think, it might be pretty interesting to people.
I've been in Alaska for the past 25 years. I spent 5 years. I'm an attorney. I spent 5 years in the Alaska bush. That's a part of Alaska that's not accessible by road. So if you want to get there, you have to fly in generally. Some communities are available by boat for certain times of the year. I spent a number of years traveling all throughout the state representing people charged with serious crimes. And for the past almost 20 years, I've had my own practice, and I've focused primarily on federal criminal defense. I came across the Reload because I'm an ardent Second Amendment supporter. I have a lot of guns. I represent a lot of people charged with gun crimes of all different types. And I really enjoyed how do I want to say this? I enjoy an intelligent, journalistic firearms perspective. A lot of what we get from a corporate media is just guns are absolutely horrible. And unfortunately, a lot of 2A media is just sort of raw guns and isn't really written at a very academically rigorous or go ahead.
An information problem. Yeah, yes. There's definitely an information problem you get on both sides of that spectrum.
Yes.
Usually major media doesn't know much about firearms generally, or how they work, or any of that stuff. And then a lot of gun media doesn't know much about politics or how, the legislatures work in real life, and
or any of that. And they frequently confuse what they want to happen with what has happened. I'll tell you who else doesn't know much about guns, and that is judges. I'm surprised a number of times at just questions I get from judges that should know better about how guns work. And it is something that really frustrating.
Comes across.
Mm-hmm.
Yeah, I can imagine, especially somebody who is defending someone on federal gun charges. That's what your area of practice?
I would say federal criminal defense, but guns are a big part of that.
Right.
And, one of the things that made me reach out to you was the Duarte decision from a couple of days ago, because
the Ninth Circuit.
We get a lot of felon in possession cases up here.
Yeah, that was the one we talked about, I think, on the show last week, where essentially the a 3-judge panel. So It's a 3-judge panel on the appeals court of the Ninth Circuit. The Ninth Circuit has a very long tradition now of taking any pro-gun ruling at that level and going en banc with it. So we'll see what happens. But the ruling was essentially found that this criminal defendant, who had been convicted of a number of crimes, but none of them were violent necessarily, and the court it was a 2-1 decision, but the court essentially decided that what he had been convicted of weren't serious crimes that would have led to lifetime prohibition during the founding era, and so therefore it couldn't stand under the Bruin standard, right? And so
Right.
that's a pretty significant ruling we're seeing out of, especially out of the Ninth Circuit. But
Yes.
I mean, just generally from a federal appeals court, I think we've only really seen one other, maybe two. I guess Daniels and Range would be the other ones that have kind of tread in this sort of territory. The Third Circuit and I think the Fifth Circuit, maybe the
Right.
I forget where Daniels is, but it's interesting stuff, and presumably is going to have a pretty big impact on what you're doing there. Because we've talked a lot with like academics or people from gun rights groups who file lawsuits, but we haven't talked a lot to criminal defense attorneys. So I'm really interested in your perspective there.
Well, the criminal defense perspective is really, it's got some really good points for Second Amendment litigation, but it's got some really bad points. The really good points are that, it's the government has to prove its case beyond a reasonable doubt. You're dealing with individual rights. You've got strong protections in that sense. The bad point is you don't get to choose your clients. And
Sure.
I look, for example, at Rahimi. If there was somebody that the 2A community would say, let's challenge the law saying you can't have a firearm if you're under the restrictions of a domestic violence restraining order, it would not be Mr. Rahimi. And that's a inherent weakness. And I've seen cases where I've gotten good rulings for my clients, and the government, because they represent an institutional client, they can say, we don't like this ruling, but we're not going to challenge it because we don't want to make bad law for us. We are willing to let one person go and maybe some evidence gets suppressed, or, a sentencing doesn't go the way that we want it. We're willing to do that rather than make bad law. But as a criminal defense attorney, I have to do, in one sense, what my client, I won't say what my client wants, but what's in the best interest of my client. If my client wants something really, frivolous or whatnot, then I don't necessarily have to do that. But if my client says, I want to appeal, and I say, you don't really have good grounds and you're going to make bad law, my client's like, I don't care. And that's a downside. But
that's interesting. That's a really interesting point because the government gets to pick and choose which cases it wants to push up to the Supreme Court, which is how we got Rahimi, right?
That is how we got Rahimi.
That's a very favorable case to the government. Whereas someone like you who's representing a criminal defendant, I mean, you just have to push with what you got because you have to work in the best interest of your client. That's part of your profession. You can't, you can't say don't appeal this because I think it'll set a bad standard for other defendants. That's his best shot as your client, then you got to do it, right?
Right. And I think, as we were talking a little bit, trying to get everything set up, I think there's going to be a lot of Bruin I know there's a lot of Bruin challenges that are going to come out of the criminal context rather than the civil context for several reasons. Number one, because you have a lot of prosecutions. And so people are filing these motions. Plaintiffs, civil lawyers, they're waiting for right defendants, right plaintiffs, like somebody that's would not be Rahimi. But also civil cases just take longer. There's a speedy trial rule in federal court. And so you do not have the reciprocal discovery issues that you do. And so cases proceed a lot faster in criminal court than they do in civil court. And so that's one of the reasons why you're seeing some of these criminal cases winding up. And that's why I think that I know that some of your listeners are going to be interested in challenges to the NFA. Those, unfortunately, I think are going to come out of criminal cases before that we can ever get to them in a civil case.
Probably, right. I mean, that's just the reality, especially with Bruin, right? Because I think you were alluding to this earlier. Bruin sets up a standard where the government has to prove that the law in question is constitutional. So all the defense has to do, and this is, I think, why you've seen a lot of public defenders have success under Bruin. There's a whole stereotype about public defenders being overworked and under-resourced. So all they have to do put up is a Second Amendment defense to a lot of these charges, and then it depends on what judge you get, I think, largely, to whether they're going to force the government to actually go through the whole Bruin standard. That seems to be not something that happens every time, but if they do, that's how you get a case like Rahimi, where it's, the guy, not a very great defendant, which, to be fair, in a lot of civil rights cases, Miranda was not a great guy either, right?
No, he wasn't.
So, it doesn't necessarily mean that the Supreme Court is going to side with the prosecution just because the defendant might be a bad guy. In a civil rights case. So, all the defense has to do is say, look, this law is unconstitutional. We think under the Second Amendment, under this Bruin standard, the government has to prove that it's not. They have to bring up the analogies to founding era law that show the modern restriction is within, the historical tradition of gun regulation. And the defense doesn't have to do any of that. They just have to make them prove it.
Right.
Which is interesting. So, a lot of that's going to come out of criminal defense. I mean, that's where, not a lot of people I've talked about this a lot in the past on the show too. And in real life, things like assault weapons bans or magazine bans, even the bump stock ban or the pistol brace stuff.
Pistol brace, the frame and receiver. Yeah.
These aren't things that actually get charged a lot, at least not as primary crimes. They might get tack-on crimes with somebody does something else. But whereas most federal law, most of it's felon in possession stuff, right? Basically, the bulk is some sort of prohibited person case.
A lot of it's felon in possession or a prohibited person. What I see, a lot of the unlawful firearms, it's not. You're right. They're not charged by themselves. They're charged with something else. So I did, for example, a number of years ago, probably the most Alaska case in my history, which was somebody was charged with unlawfully selling polar bear hides, walrus tusks, and machine guns. And that's just in Alaska. That's just
Alaska
or
Florida, I guess.
Yeah. So it does come up out of that, but I think that's why I think that the NFA challenges will come out of. But you look at, I think that you've got a whole issue with the domestic violence misdemeanor convictions. For a number of years, there was a case in the Ninth Circuit, and there were similar cases in other circuits, but it wasn't certainly unanimous. But in order to be convicted, you have to have a mental state and an action. And mental states, it generally there's four for the most part. There's intelligent, intent, knowing, reckless, and negligence. And the mental state for assault in Alaska and Hawaii and some other states in the Ninth Circuit was reckless. And the Ninth Circuit had said, you really can't be subject to the Lautenberg Amendment, which was not being able to purchase, possess, or transport a firearm after having been convicted of a domestic violence misdemeanor based on a reckless mens rea. Well, after Heller, but before Bruin, that went up to the Supreme Court. And the Supreme Court said, we think you still can do that. And Thomas dissented. I can't remember if there were others, but Thomas wrote a dissent and said, I have a hard time believing that you lose your Second Amendment rights just because of a misdemeanor, but that issue hasn't really been raised or briefed. It was all about the mens rea issue. And I think that is an issue that's going to be, that will come again out of the criminal context. Although I've got a client that wants to file charges because he had a domestic violence conviction many years ago. And he's like, I can't own a firearm now. And one of the issues, particularly with domestic violence, is, and this is an issue that I wonder where the Supreme Court is going to go with Rahimi. Those domestic violence restraining orders and domestic violence convictions are very common because for the restraining orders, judges are far more likely to just grant one because there's very little downside to not granting one.
That was brought up in the oral arguments.
Yes, in a lot of the amicus briefs. And then the other issue is that with domestic violence convictions, and you said something earlier that's true. There's sort of the reputation of public defenders. I've been a public defender, and I think that's very true in state court. States don't want to fund them. It's not nearly as true in federal court. Federal court, because the federal defenders are part of the court system, they're viewed as an equal to the U.S. attorneys, and so the pay is the same in terms of their categorization. The resources are the same, and in fact, they even have a provision that a certain number of cases are supposed to go to private attorneys so that they don't overwork the staff attorneys. But a lot of times, your staff attorneys on your state cases, particularly handling misdemeanors, they have so many cases, and it's just, hey, try and
people plead down to these lesser charges just to sort of get the situation over with, and they don't understand.
Mm-hmm. And a lot of states now make it such that it's a felony if you put your hands on somebody's neck. So what I've seen is, and I've had cases like this. A woman, gets pretty angry at her husband or her partner, and he starts to push her away, and he puts his hand out and he puts his hand on her neck. And then when the police come, she says, "Oh, he put his hand on my neck." And, you can see the kind of the reddish mark on that. And then he's going, "No, I did that to push her away." And suddenly he's charged with a felony. And, there's the marks. It's your word. It's her word. And the prosecutor says, "Well, I'll make you a deal. It can be a misdemeanor. And then you're not a felon." And not every attorney knows. And they're like, "Oh, you won't have any issue because it's not a felony. You can still own your guns." Well, no, you can't. And that happens.
Well, yeah, I guess it'll be interesting to see where all that shakes out. I just think the court's probably going to have to take a lot more Second Amendment related cases before any of this really gets fully sorted out, especially after Bruin, because there just isn't that much, at least not Supreme Court jurisprudence on this stuff.
There isn't.
And it probably will be a lot of criminal cases, like you're saying. Just the last question here before we head out. What have you seen it's only been 2 years, right, since Bruin was handed down. How has that affected your practice? I don't know. Do you have current gun cases? You don't have to talk in detail about them, but what have you seen?
I'll tell you, today I'm going to be filing a motion to dismiss an indictment based upon Duarte. And I was actually telling my client, let's wait for Rahimi. One of the issues in Duarte, there was a case that came out in 2011 called Vongse, and Vongse upheld the felon in possession rule in the Ninth Circuit. Well, Vongse did not go into any sort of historical analysis. Vongse did not look at the history, the text, the tradition. And in fact, Vongse made the petitioner, the plaintiff, the defendant. He's a petitioner, which means he's the appellant. He's the defendant. They made him have the burden of proof to show that the law was unconstitutional on an appellate basis. Again, it's a 2011 decision. Okay. After 2022, what did judges in the Ninth Circuit do? All of them said, "Oh, hey, Vongse is still good law." No, it wasn't. And that was a really significant part of Duarte, was they spent several pages saying, here's the law in the Ninth Circuit as to whether a subsequent case overrules a previous case. And here's the criteria, 1, 2, 3, 4, 5. Here's what Bruin did. Here's how it affects Vongse. Vongse is overruled. And then they went through, I really like the Duarte case because they've got really good language. But, the government trots out the whole, hey, we could disenfranchise anybody we want because look at all the people that were disenfranchised at the founding. And they went through and said, no, that's not the case because number one, they weren't permanent. Number two, it wasn't permanent in terms of the law. That is, the laws were quickly revoked, but even the disabilities were not permanent. So even under the law, you could get your gun rights back if you were a Catholic in the French and Indian War because they were concerned that, hey, we're fighting the French. The French are Catholic. We're English. You're going to sympathize more with the Catholics. Well, guess what? You could take an oath of allegiance to the English, to the colonies, and get your gun rights back. if you were sympathetic to the British in the Revolutionary War, you could take an oath of allegiance. And so,
Yeah. So
Yeah.
so you're saying this decision that Duarte, which does undo this 2011 Ninth Circuit. This is all we're all talking about the Ninth Circuit here. So it's only part of the country, but it's obviously one of the more fascinating rulings because that circuit has traditionally been known as the most liberal circuit. And so this is going back to this is the 3-judge panel. They could still go en banc, and they usually have in these sorts of situations. So we'll see what happens, but it's a pretty monumental decision, and you are seeing a direct impact on the cases that you are personally litigating, right?
Yes. And so I think the timing of this decision is very interesting. Even if they vote for it to go en banc, Rahimi is going to come out before any argument. I expect, I think that it came out of the Ninth Circuit, which is significant for several reasons. Number one, as you said, it's viewed as the most liberal circuit. Number two, it's been historically pro defense rights, but it's also been very anti-Second Amendment. And so I think that the pro defense rights actually kind of won this one. Plus they had Van Dyke on the panel. It's got a lot of good language. And I think part of the reason that it came out now is to sort of influence Rahimi. I could be wrong, but I would be willing to bet that whichever justice is assigned to writing Rahimi, that justice's clerks are reading Duarte and looking at it. And I would be surprised if there's not at least some citation to Duarte in the Rahimi decision when it comes out.
Well, we will have to wait and see what happens with that. But we really appreciate you doing this with us for one of these member segments. It's always my favorite segment. Get to talk to some of the folks in the Reload community here, and I think your point of view is perhaps especially interesting to the rest of our readers, given your on the ground, day-to-day experience with these sorts of cases. So I really appreciate you shedding some light on what's going on. Maybe we, in the future, if you have a case that might be of interest to the Reload readers, or maybe we'll have you back on, or at least I get some quotes from you. Because I always like to hear, in addition to the academics and the civil litigator type guys, it's good to hear from the people who are more in the trenches of this stuff, right? So really appreciate it. But that's all we've got for this week. If you guys want to listen at home, if you want to join the Reload, if you want to be a member segment, you can get over to the reload.com and buy a membership today. And part of what you get.
It's worth it. Do it.
There you go. That's a good endorsement right there. But one of the perks is you get to be on the member segment if you would like to. So head over today and check that out. That's all we've got for you this week. We will see you guys again real soon.